Dumelang, welcome to Face the Nation. My name is Clement Manyantela. Great to have you with us here on SABC News. On the show tonight, why is the DA against legislation that's intended to transform the workplace and address underrepresentation of certain racial groups, women and people with disabilities? The party has taken the government it's part of to court over the new employment equity targets for companies. The amendment of the Employment Equity Act empowers the Minister of Labour to set numerical targets for equitable representation of suitably qualified individuals from designated groups at all occupational levels. The DA will tell us why they are against the law, and the Department of Labour will respond and tell us why they are in defence of it. Also on the show, as things stand now, can South Africa prevent state capture 2.0? The state capture inquiry cost about R1 billion and revealed the extent of the rot in government. But what has been done to avoid a repeat of state capture? The man who was responsible for leading evidence at the inquiry, Advocate Paul Pretorius, joins us tonight. But first, my comment. So the DA has taken the government that it is part of to court over the employment equity targets for companies. So the party is against the amendments to the Employment Equity Act. The amendments, what they actually do is empower the Minister of Labour to set numerical targets for equitable representation of suitably qualified individuals. And I emphasize that suitably qualified individuals from designated groups at all occupational levels. These are flexible employment equity targets. They're not rigid mandatory quotas, right? Employers can set their annual numerical targets in their employment equity plans, which must comply with the sectoral targets. Employers can also justify the failure to meet the targets on reasonable grounds, obviously. And the aim really is to address the underrepresentation of the designated groups in the workplace in relation to the economically active population. But employers would be required to comply with their own set annual employment targets towards the achievement of 5-year plan sector targets. So non-compliance with the Act carries severe penalties, including the inability to do business with the state, the cancellation of contracts and fines. And there are questions, of course, about whether or not that's even severe enough. And that's a question I'll be asking the Department of Labour. But what the DA is arguing is that if the law is enacted, a specific group concentrated in a geographical area could face exclusion from employment based on national targets set by the minister. Here's one of their lawyers in court making an argument today.
It's not the particular subordinate legislation or targets that have been promulgated in any particular case. They all, and that's why in 014, the notice of motion, we in para 2 want a declaration, if you're with us, my lady, and you declare the Amendment Act unconstitutional and invalid, whether in its entirety or separate parts of it, then as a consequence of that, we ask in 2 that any enactments promulgated in terms of 15A be declared unconstitutional.
So the party argues that the best path to achieving redress is through economic growth, through job creation and inclusion. They argue that the new targets would drive away investors and shrink economic growth. Government, on the other side, argued in court today why the targets are necessary. Take a listen.
One thing that must be borne in mind, my lady, is that we're not dealing here with the targets which were drafted at the time when the matter was started and which have gone through various iterations. That is not the basis of the arguments that the leadership or the decision that leadership must make. The question centrally centers on the legislation itself. Does 15A contravene any of the constitutional requirements, not the targets which have been set out? 15A creates a framework. 15A is not the targets themselves. And so one cannot transpose what the targets say in either draft forms. That because the targets as constructed favor this or that grouping, that therefore that means that the Section 15A itself is unconstitutional. One must distinguish between the legislation itself and its application. You may apply it in a way that is constitutionally unacceptable, but that does not mean that the legislation itself is unconstitutional.
That was part of the argument by the lawyers representing the Department of Labor. The question we have to ask ourselves is what must be done to redress the injustices of the past? What must be done to level the playing field? I think once again, the DA, at least in my view, has demonstrated how unserious it is about transformation. They never have they? The Commission for Employment Equity revealed year after year that workplace transformation remains sluggish. Its annual report always shows that there is still an overrepresentation of white males in top and senior management positions, and this is in all provinces. So basically, white males are still ranked high in top management positions at, well, the last I checked, it was at 56.4% in the private sector, and black Africans occupy only 15% of management positions. How do you explain that? And I think companies are clearly refusing to transform, and I wonder if the companies realize that by refusing to comply with affirmative action, they are an impediment to the country's progress. So government must do what? Just look away with the history that this country has? The original Employment Equity Act of 1998 was implemented with the aim of addressing the country's history of structural exclusion on the basis of race. So as companies fail to transform, government has to think about ways to make companies to transform. So these targets the DA is challenging will be based on the reality of the various sectors. But the DA somehow wants you to believe that colored people and people of Indian descent in KwaZulu-Natal are going to lose their jobs, and yet the regulations seem to say something different. President Cyril Ramaphosa said last week he wants to know what the DA's issue is with transformation.
Go and read our constitution very clearly and very carefully, because what we are seeking to do is to transform our country and to ensure that what apartheid bequeathed us is something that we correct. So the Employment Equity Act is aimed at doing that. But as any organization is entitled to, they're entitled to go to court, and I haven't had their full complaint. I'd like them to come and explain to me what grudge they have about transformation.
So the question we're asking you tonight is, how can we make companies to be more serious about transformation? Because if it wasn't for the private sector's refusal to transform, government wouldn't have to implement these numerical targets. So what do you think needs to be done? Share your thoughts with us. You can send us a WhatsApp voice note on 078-459-1897. Remember to tell us your name and your surname and where you're sending the voice note from. And please keep it at 30 seconds. Alternatively, you can send us an X on @FaceTheNation SABC. We'll be back after the break. Welcome back. The judgment in the DA's application against Section 15A of the Employment Equity Act has been reserved. Section 15A of the Employment Equity Act will give the Minister of Labour and Employment powers to set targets, in particular, employment sectors. The DA has described the new amendment act as unconstitutional and unfair, arguing that this move by government is introducing racial quotas. In a recent statement, the Department of Labour and Employment noted with dismay the DA's stance against transformation. That's what they said. For more on this, we're joined now by the DDG of the Department of Labour and Employment, Thembinkosi Mkalipi, and Michael Bagraim, who is the DA spokesperson on employment and labour. Michael and Thembinkosi, thank you so much to both of you for making time for us. I'll start with you, Thembinkosi. How is this Amendment Act going to help in promoting diversity and equality in the workplace?
Well, this amendment is intended to give some teeth to the inspectors to ensure enforcement, is intended to put more pressure on employers to implement and follow the law, and with the penalties, the ability to business, and obviously, as you indicated, that employers who have got justifiable reason who are not able to meet the target that they've set themselves can raise justifiable reason. We believe that with all those put in place, this act will assist and move transformation.
Yeah. So then the numerical targets then would be set for what? Equitable representation of suitably qualified individuals from designated groups at all occupational levels. How much say do employers have on those targets? Will they be based on the reality of the various sectors?
Well, I mean, first, the targets that are set have been a result of consultation since two years ago. We've been consulting with the different sectors and as you know, these final targets that have been published are not the first targets. We had targets that were published for public comment, and there were comments on those targets, changes were made, and now we've got these targets. Therefore, there's been interaction with employers on this. And the other issue, as you indicated, that these targets are 5-year targets that the minister has said. Employers have got a responsibility to make their own target on how to meet this 5-year target. And it's those annual targets that will be assessed, that are set by employers, not by us, on whether they comply with this law or not.
All right. Michael, what exactly are you challenging about that? Why are you against this legislation that the Labour Department says wants to see more diversity in the workplace?
Well, clearly they don't. This law has been in place for 27 years and it's been a failure from day one, and it's getting worse. And you're both wrong. It's not targets that the employer set. The minister has set these targets. She keeps saying she consulted, and the previous minister said he consulted. Well, we don't know who they consulted with. They certainly didn't consult with the Employment Portfolio Committee at Parliament. That they didn't do, which is wrong in the first place. But the reality is that it's got worse and worse. And now to set it in stone, because it doesn't matter what the employer says. If the employer says, I'm going to set a target for myself for year 1, year 2, but at year 5, they have to hit the minister's target. It's cast in stone. That's the way it's written, and that's why 15A is actually unconstitutional. The whole idea of the legislation is to call for redress. The Democratic Alliance wants very carefully to call for redress, but real redress, not redress that doesn't happen. Doesn't want to call for redress that goes worse every year. Mr. Mkalipi can say what he wants, but the bottom line is those targets are set. And once a target's been set, the minister's not saying, don't worry, if you've got some good reason as to why you can't find people, we'll change the target. That's not the way it's worded. She's going to have to go back to the drawing board and reword it if that's the way they're trying to argue it. But even his own lawyers in the courtroom did not argue that. They're saying themselves that it might be unconstitutional. And we're going to obviously hear from the court now. It's no good us arguing the law itself, but we've got a real problem. We've also put in another plea in this particular case, that it's not been properly pleaded through the courts, through the Parliament itself. It's not been tagged properly. So that's another constitutional point that we're making, in the sense that it's supposed to go through Section 76 and not 75, and it's a mess. The whole thing's a complete mess. Now, what we do know as an alternative, the DA has put forward lots of alternatives, but the main alternative is to ensure that we actually get more work going, we get more people into the workforce. It doesn't help to say, oh, well, we're not going to employ any white males. That's fine, but if you took all the white males and you threw them into the sea like Julius Malema wants to do, the economy's not going to get better. Okay, Michael, it's certainly not going to get better.
Yeah, we'll talk
so
about
you're wrong. You are wrong. In your introduction, you were completely wrong.
Okay, you can hold that view. I'm okay with that. I need us to talk about those options much later, what you are suggesting as the DA. But also in this legislation, nowhere does it say white people must not be employed. Here's my question, though. When you are saying that this legislation has failed since the beginning. How do you measure that? There are many people, black South Africans in particular, who are watching us right now, who are in their positions thanks to the Employment Equity Act. So when you talk about failure, how have you actually measured that?
Well, quite simply, you can't say that they're there because of the employment. That's actually shameful for you to say that, because people got there by their own merit. People got there because of hard work, because of their ability. They didn't get there because of the color of their skin. That's not the case. And you've said that in terms of the figures. People in those positions, for instance, the leaders in the banking community, the CEOs, they didn't get there because they're black. They got there because they are brilliant, brilliant people. And they got there competing with everyone else. They are able and willing and able to do the job. That's not a problem. People didn't get any jobs because of employment equity. In fact, we're losing jobs because of the way the employment equity is going. So it's really sad that you will have to say that a black person got a job because of employment equity. That's very sad. Well, and that we shouldn't live through that. It's like when Nats used to say that we're going to have Afrikaners in jobs, and that's why they got jobs. They employed racial quotients, and this is what we bring it back again.
Yeah, Michael, it's not shameful. I'm proud, in fact, to be working for some companies as a result of the Employment Equity Act. It's not a shameful thing. So as black people, we actually understand the history of this country. We understand where we come from. You had the privilege of all the jobs that you wanted during apartheid. We didn't have that. There's a government that came in that said that has to be corrected. They put in legislation that is going to make sure that we are going to be given opportunities. And I want to come back to this misguided view of the Employment Equity Act as if it doesn't talk about merit. Where in that legislation does it say just go and pick up any black person and put them in a position? Because that legislation is very clear. And I said it in my comment. I repeated it for the viewers because I know that's a lie that is constantly told by parties like yours that, oh, if you talk about employment, I will. Hold on. I'll give you an opportunity to respond. You always say that you mention the issue of merit. Always. That we need people to get jobs in terms of merit. Where in the legislation does it say that merit is not the first consideration? Because my understanding of the law, as I've read it, is that suitably qualified candidates are the ones that must actually be considered even when you are implementing the Employment Equity Act. So merit is the most priority of all things. Nobody says go pick up a woman just because they are a woman. Go pick up a black person because they're a black person. So help me understand where in this legislation does it say that merit is not a consideration?
Well, where's the DA ever said that? We've never said that.
You've just said it now.
Always in. No, I didn't.
Now that
I did not. I did. You said it. No, I didn't say it. Now listen to me carefully, because you're putting words in my mouth and it's wrong. We've always said that merit is part of the legislation. What we're saying is that no one has been employed because they happen to be black. No one's been employed because they happen to be white.
Who said that?
I'm saying that. I'm saying merit is definitely part of it.
But who has said that?
The DA has always said.
Who said people must be employed because they are only black?
You've just said it now. You said you got your job because you're black. You didn't. You got your job because you were able.
There are a lot of people watching us now who have actually been given opportunities thanks to employment equity legislation. That's what I've said.
I don't believe that. I don't believe that.
And you chose to think that because I say people have gotten jobs through the Employment Equity Act, oh, it's a shame because I'm suggesting that they were employed just because they're black. No, employment equity legislation talks about merit. I've gotten jobs because of that, because I'm brilliant at what I do, not because I'm black.
Correct.
Because that's what legislation says. Legislation says there must be merit. Where does it say?
And that's a small thing that I agree with you. That's the only thing that I agree.
Oh, now you agree. Okay.
But no, I have always agreed with that. And the DA has always agreed with that.
Oh.
But the point is, you didn't get your job because of employment
Nobody
equity.
said that.
You did not.
I did.
You've just told us that.
We got it. There are many people who've gotten jobs thanks to employment equity legislation, which stresses the issue of legislation. Thembinkosi, let me bring you in here. Michael raises an issue about targets that are said, that even when the minister says, well, we're going to, if you've got justification on reasonable grounds, you can help us understand as a company why you're failing to meet the targets. Help us understand what the legislation actually says, because there's an impression being created that if you are a colored person living in the Western Cape, a company may just the minister may set targets that are going to disadvantage you. Or if you are someone of Indian descent who lives in KwaZulu-Natal, in Durban, the minister can set targets that are going to disadvantage you. That's the position the DA has been pushing. Is that what the legislation says?
It's very disappointing. Mr. Bagraim is a lawyer. She should understand what the law says. First, let's start with the law. The law says any employer that is implementing this legislation must use regional and national demographics. That's the issue. That's what the law says as we speak. The regulations that have been published says a company must make a selection. When they decide, the minister set the 5-year target and said, in 5 years we should be here at point A. The company then must decide how it would reach that point A. Company A would say, well, I'm going to be 20% in the first year. And that company A will say, in that 20%, I'm going to use regional demographic. That's a company making that choice. If it says we're going to use provincial demographic, it will use those provincial demographic.
Yeah.
If the company says we'll use national demographic, it will be assessed on the basis of national demographic.
Mm-hmm.
It's a choice that is made by the company itself in terms of which demographic they will be using in meeting this target. Now, DA doesn't talk about that. It's in the regulation and in the law. The law says you must use both. The regulation unpack it better and says you should decide which demographic you want to use. But the DA will never raise that.
Okay. Let's find out. Michael, are you aware of that? Because I also heard Helen Ziller before talk about the issue of the colored population that may be disadvantaged. In fact, just the other day, she mentioned that people of Indian descent and said when the last time she checked, it was about 3% of them when you look at the demographic. But the legislation says the companies themselves can choose if they want to use regional or provincial demographics, which would mean that in fact you're not considering the 3%, you're considering whatever demographic is applicable to you in that region or in that province.
So you're both saying, unbeknown to your lawyers, you're both saying that those quotas can be varied. Is that what I'm understanding? Because that's what I've just heard from both of you. And the minister's not saying that. The minister has set the quotas and has set on stone. So it's not varied. It's not, if you choose this, you can have a different quota and be a third quota for another province. That's not what it says in the 15A regulations of the quotas. What it says is, this is what you will reflect in 5 years' time. And if you choose something different, you still will reflect the quota that the minister said. If now Mr. Mkalipi is now saying on record that the department has changed its mind and those quotas can differ compared to what you might choose as a company, well, that's a different argument altogether, and that's something that we might have to face in another court case, because this court case doesn't say that. This court case is argued by the government's lawyers that the minister has set quotas, not targets, quotas, and those quotas are set in stone. And she has set it, and you can choose how you can get there. That you can do, no problem. But the quota's there. Now, if you've got too many Indians in KwaZulu-Natal in a company and you haven't matched the quota, well, then you can't employ more Indians. Quite simple. And Helen Ziller is correct. So now Mr. Mkalipi is telling us that those quotas are movable. It's a moving target, which is very interesting because we didn't hear that from the lawyers of the government at all.
Okay, Thembinkosi, when I looked at the regulations, from the time there was an amendment, was it 2 years or so ago? I mean, I interviewed even the Minister of Labour at the time, and this was always my understanding. This was always my understanding that there is, in fact, going to be an opportunity for companies to choose for themselves. So have you guys miscommunicated? Because the DA clearly is unaware of that.
Mr. Bagraim is a lawyer. Mr. Bagraim should be sitting here and saying, it doesn't matter who says what. Whether the person is a president, whether the person is a minister, what is important is what the law and the regulation says. And we're saying, the regulation that have been published the first time a year ago and the regulation that are prevalent now says exactly what I'm saying. And I'm challenging Mr. Bagraim as a lawyer to go out and use his skill and training as a lawyer. Look at the law, look at the regulation. It gives employers the choice to decide which demographic they need to use. Don't make argument to bolster your case and make allegations that do not exist, Mr. Bagraim. You are a lawyer. Please respect the profession.
Yeah, Michael, if this is the position of government, I mean, I don't know when last you checked the regulation, but I've always understood it to say that. So if really this is the case, right, when you go recheck again, that employers are actually going to choose for themselves what sort of demographics they use, whether regional or provincial, because then that takes away what Helen Ziller said about colored people or Indian people in Durban, in KwaZulu-Natal. Then if that's really the case, how the regulation are stipulated, then do you still have a case to argue that people are going to be losing jobs because of this?
Yes, absolutely. And in fact, I'm mouthing what the government's lawyers said. So I've read it, yes, and I've read it recently, 2 days ago, and I'm very happy that the minister, I'm not happy with it, but I'm happy to say that the minister's chosen quotas. She hasn't got varied quotas, they are quotas. And she tells you how many blacks, how many coloreds, how many Indians, how many women, how many disabled, it's put there for each industry. It's not a varied thing. It's not saying, well, approximately this in accordance with what you might choose and whether it's going to be regional or national. She hasn't said that, but nor did the government. Maybe if I'm wrong, then the government's lawyers have argued wrong as well. So I don't know where both of you are coming from, but there's quotas. It's not targets. It's not something that the minister said is variable. Have a look at it again. You go and look at it before you ask me the wrong question, because you're putting words in my mouth and saying that it's now variable. You can choose whether it's regional. You can choose whether you've got enough people who can come in. You can have all sorts of excuses. But after 5 years, the minister has said this is what it will be. And this is why it's a blunt tool. It's a very blunt tool, and it goes against the whole idea of redress. It goes against it completely.
Yeah, I want to move to another point, but Thembinkosi, I think maybe after this conversation, you need to go and repost and republish perhaps those regulations, especially the parts that speak to the companies having that carte blanche to actually choose for themselves what demographics they're going to apply. What I'll also do is just tweet that for our viewers that may be confused right now. But as I said, I've covered this story many times since this amendment was introduced, and it's always been my understanding. So I'm confused how now, about how many, 2 years later, there is no understanding of that from other parties. But we'll tweet that and look at it. I want to ask Michael, as the DA, are you encouraging companies to transform? And how have you done that? Because I would imagine as the DA, you do appreciate the history that this country has. The playing field is not leveled. At some point,
Absolutely.
The playing field needs to be leveled. So what are your ideas? How do we level the playing field?
Thank you. Yes, that I agree with you entirely. There is a real problem out there because the top echelons, especially of the top echelons of the business community, is pale and male. And it hasn't been leveled. And we need to level it. And the whole idea is not to do the same experiment that the government has done for 27 years. So what did we do? Where we do have some control as a Democratic Alliance, we've tried the experiment. It's been about 8 years now worth of that experiment. And what have we done? We've looked at the Western Cape, and we've, despite the legislation, because we've had employment equity in the Western Cape as well, we can't escape that. We're a party of rule of law. We don't break the law. We follow the Constitution and we follow the law. And even following the law, what we've done is we've deregulated, we've actually helped small businesses, and we brought the unemployment down in the Western Cape to below 19%, when the national government has sitting at 42%. Well, I'm quoting COSATU. They say the expanded definition of 42%. They're saying, COSATU is telling us that almost 70% of the youth are unemployed. So it can't be the same as normal. What we're saying is, and it's an old Einstein statement saying that if you do the same experiment, getting a bad result, and you want to get a better result, it's a sign of madness. What we need to do is we need to bring the unemployment down in South Africa. We need to improve the economy. We need to improve the education system. yes, white males had the benefit of apartheid. And yes, we've got a real problem in this country, and we've had now 31 years, and we haven't solved the problem. But you're not going to solve it by tightening the screws on an experiment that hasn't worked. We need something else. And we're in this together. We're in a GNU. What we're begging the ANC to do is to let's work out together how we can get them to reflect the demographics of the country. Our neighbors, Nigeria is a perfect example. They don't have employment equity legislation, but they reflect the demographics, and their economy is soaring. They're overtaking us. It's an embarrassment.
Did Nigeria experience apartheid?
Well, worse, they experienced the colonialism. And yes,
guess what?
The whole of Africa.
Guess what, Michael? Guess what? We experienced both colonialism and apartheid.
And yes, and I agree with you. And I think it's very unfair what's happened, and we still haven't moved away from that. But we need some other tool to ensure that we reflect the demographics of the country. Our people are industrious, they're clever, they're hardworking, they don't want to be called people who got pushed in because of their color. They want to be pushed in because they work hard. They are brilliant, brilliant people. And we need that in South Africa. We need to do it. We need to pick up. We're all in both South Africa. I'm living here. I'm not leaving. You're living here. You're not leaving. We don't want to see every family affected by unemployment.
Just for clarity, before I go to Thembinkosi, I'm a little confused because earlier on you said we can't continue with this legislation because it's failed, this But now you've just said that in the Western Cape you've used Employment Equity Act and you've managed to push down
I said despite.
Yeah?
I said despite
Despite it.
Because
you didn't implement it. So you haven't implemented it in the Western Cape.
We had to implement it, but despite that, we had to look at other ways and means.
What are those ways? Please share those with us. Give other provinces those tips, please.
Yeah,
how have you done it?
They are talking. They are talking to the other provinces, especially the northern province now. But what's happened is they've deregulated as much as they can. They've got rid of red tape as much as they can. They've put in workshops. They put in finance to build up, because it's the small businesses that are employing people, not big business. Big business is going through a situation where they got jobless growth. So big business is not our future. Small business is our future, and they're employing, and that the economists around the world are telling us. So what do? You encourage small businesses. You go to the spaza shop, you give them training, you give them finance, you help them with any red tape that there might be. And you say to them, employ 5 extra people and build your business and we'll help you. And that's what they're doing. It's hard yards.
If they employ 5 white people?
Well, they might not. We're not telling them who to employ, but obviously we've got employment equity. We can't tell people to break the law. That will never do. So if there is employment equity, yes, we understand that, and we've got to stand by the law. That's why we're going to the court. We're not telling people to break the law. So employment equity actually does force companies to do what is right and give also black people an opportunity. Okay, Thembinkosi, as government, how many inspectors is the word I'm looking for. How many inspectors do you have? Because you can change legislation and announce all these punitive measures all you like. But as the department, you seemingly have failed to rein in these companies that have failed to transform. Because every year you come up with a report, the Employment Equity, the Commission for Employment Equity tells us the same story of how the transformation picture is not changing, and yet we are still sitting here. So how many inspectors do you have? Do you have enough to actually hold these companies accountable? And these punitive measures that are in this legislation, are those enough to force government to actually transform, to force the private companies to transform?
Now, I think there's a myth that we need also to need to start with first before I answer your question.
Yeah.
The first thing is this. Mr. Bagraim and the DA says every day, and they are correct, that the Western Cape as a province, when State South Africa release data in terms of jobs created, is higher than other provinces. There's no doubt about that. But there's no correlation between that and transformation in the Western Cape. When you look at the Employment Equity Report, look at the Western Cape, compare it with the other provinces, it's in the same basis, although the economy has grown a little bit higher. There's no transformation in the Western Cape. Look at the last report that was issued by the Employment Commission. Look at the report that the Commission is going to issue next month for the last financial year. Transformation is the same in the Western Cape as in other provinces, although they say they have got a better growth in their sector. Therefore, there's really no correlation between transformation and if there's no will by employers, whether the economy grows or not, is not going to make any difference. That's the first issue that I needed to put it, because the Western Cape is the test case on this. We can see it in the Western Cape with the growth that they say they have. Now, on the issue of enforcement, I agree with you that in the past we have not been doing what we need to do to enforce this law. But with the regulation, now the checking on this is all now automated. When the employers report, that report will indicate whether the employers have been able to meet the target that they've set themselves on an annual basis. And the system is going to say to that employer, you have not met your target. Therefore, you are not getting a certificate of compliance. Therefore, you are not going to be able to do business with government unless you are able to give us justifiable reason why you did not meet your target. And the law and the regulation give them a list of justifiable reasons that they can choose from. And we believe those measures are going to assist us in enforcing this law without having to send inspectors in. When we publish a report in 2027, the report will indicate which companies have met the targets that they set themselves, which companies have not been able to meet those targets, what are the justifiable reasons that they are citing for not meeting those targets, whether the inspectors that go on in the last financial year have been able to agree with them on those justifiable reasons. Because by selecting a justifiable reason does not necessarily mean you are correct. Example, you've got Nedbank one side who says we're not been able to meet our target. And the reason is because the economy has not grown and we're not able then to get more people. Then we say to them when we meet with them, but how come is Standard Bank in the same sector with you, faced with the same environment? They've been able to meet their target with no problem at all. Can you justify, can you explain that to us? That's a conversation that we'll be having with those companies who has selected a justifiable reason. A justifiable reason is not a ticket on this issue. You select it, then there's got to be a conversation. And from our side, we've got to change our approach and the way we engage with employers on this issue. The other issue that I really need to clarify is when he says that 5-year targets, they must be met. Now, if company A in the first year, they say, we've got this justifiable reason and we accept it, it's acceptable, therefore we're not able to meet our target. Nothing prevents them to say, raise the same justifiable reason the following year if it's still there. The third year if it's still there. The fourth year if it's still there. Because it does not cease to be justifiable because now it's the third year and the fifth year if the reason is still applicable.
Well, the DA says they were not even aware of some of these things you're mentioning.
Well, I thought it's us who are black people who are not comfortable in reading. I didn't know that even the DA members and the leaders don't read the law because that's what the law says. And if we say raise a justifiable reason, that section doesn't say you raise it once in 1 year. You can raise it every year as long as it's justifiable.
All right.
We can't say this year it's not justifiable, that year it was justifiable.
All right.
And Mr. Bagraim knows that.
All right. DDG of the Department of Employment and Labour, Thembinkosi Mkalipi, and Michael Bagraim, who's the DA spokesperson on employment of labour. Thank you to both of you for making time for us tonight on Face the Nation. So the question we've been asking you tonight is what exactly needs to be done to ensure companies take transformation seriously? Because clearly they have not. And that is why you've got a government now that's coming with all sorts of ideas, including these targets, to try and force companies to transform. Some of your tweets that have come through, Palisa says, until such time that the Act criminalizes companies who do not implement the Act, the status quo will remain, making employment equity compliance a prerequisite for accessing state contracts is not good enough because there are other companies that do not do business with the state at all. Rabotata says transformation is not optional. All companies must comply with transformation policy to redress apartheid inequality in companies. Companies not complying with transformation must be legally charged. Liesel says the majority of the colored and white people are looking for work, but only blacks get work easily. Thank you so much for your tweets. We have got your WhatsApp voice notes as well that have come through responding to this question we're asking you about what companies actually need to do. In fact, what government needs to do. And as you heard from the DG of the Department of Labor, they need to really strengthen their compliance mechanisms because they don't have enough inspectors. So you can have as strong a legislation as you want. If you are not going to regulate and ensure that there's accountability mechanisms, then we're going to be stuck here once again. Here's what some of you have said on the voice note line.
Good evening, Clement, and your viewers. This is Thembinkosi from Albertine, Gauteng. I'm talking from experience. The reason this thing is not happening is because the people who are responsible for the implementation, they are not implementing. So there is no will to implement this transformation. Thank you.
Hi, Clement. This is Jerome. Well, my view is that the government has had 30 years to transform the labor market, the Employment Equity Act. 30 years. They have failed to implement it and to bring reform, proper reform, even in the public sector. In the public sector, in state entities, we have found that the labor practice there has caused it and has brought about corruption, inefficiencies, malpractices. It's rampant. And now they want to tap in to the private sector's ability to do business and corrupt that as well.
Good evening. My name is Oria. Well, I think the DA is wrong in private sectors. But what they should have looked at or focused on is in government departments and also in municipalities. I think there, because I can see there's no fairness there with regard to employment equity. Whites, Indians, and coloreds are being overlooked there. So there must be a redress in that regard. Thank you.
All right, thank you so much for all of your comments. We'll be back after the break. Stay with us here on Face the Nation. Welcome back. While South Africa is grappling with the challenges within the Government of National Unity, debates about how big the impact was of state capture and corruption rages on. These conversations continue to dominate both political and economic landscapes. The Commission of Inquiry into State Capture, headed by retired Chief Justice Raymond Zondo, is hailed by many as a timely intervention to thwart and defeat state capture. The elephant in the room, though, is the lack of arrest and conviction of those alleged to have engineered this phenomena. We're now joined in studio by the former evidence leader at the State Capture Commission, Advocate Paul Pretorius, Senior Counsel, joining us in studio. Advocate, thank you so much for making time. Good evening.
Great pleasure. Good evening.
Let's start with a discussion about your work at the State Capture Commission. I mean, you spent years investigating and leading evidence at the inquiry. Given how much investigators uncovered, does it make sense to you that we still don't have a lot of successful prosecutions?
Well, it does make sense if you look at the context of what is happening at the moment. It's not satisfactory by any means that the response on the part of law enforcement agencies has not been satisfactory. At two levels, corruption continues, and that's very important. It has not been stopped. Now, that's a systemic issue that must be dealt with systemically. Yeah. The NPA itself has attempted within the confines and its own context to investigate and prosecute. But let me give you one example. At any one stage, the Commission had 100 investigators at its disposal, working 24/7. When last I checked, and it may have changed now, but not too long ago, months ago, the investigating directorate had about 20 of its own investigators and borrowed others. So the capacity of the NPA is a huge problem. The technology is an issue that needs to be addressed. Its access to the Zondo archives is an issue that needs to be addressed. There are so many issues in analyzing this problem. It's not just an easy issue to analyze and come up with answers.
Yeah, if we can spend R1 billion on the state capture inquiry, I mean, why can't at least half of that sort of amount of money be invested in capacitating the NPA? Is a question I often ask myself.
Well, it's not only an important question to ask, but the question is, who do you ask that question of? Who is the accountable entity? The NPA is not independent. It doesn't control its own purse strings. And in essence, it falls within the Department of Justice and within government. And those questions must be asked where they should be asked and answered by those who should answer.
Yeah, and I asked the Minister of Justice, who was on the show, that question a while back. And speaking of the Department of Justice, is there from the last, when you were still with the NPA as a consultant, was the issue of evidence that was located within the Justice Department resolved? Because at some point, the NPA head, Shamila Batohi, told me when she was on this show that at some point she had to subpoena the documents, and you wonder, why would they need to subpoena documents that are supposed to be so easily available to an institution like the NPA?
After many years, and I stress years, which in itself is unsatisfactory, and much interaction, which wasn't always polite, I must stress, and not always cooperative, I believe that very recently a system has been worked out between the Department of Justice and the NPA for access to the Zondo archives. But the fact that that has to be a site of struggle almost over so many years is just simply unsatisfactory. The DOJ sort of said to the NPA, here it is, which was intended at some stage under the previous ministry.
From what you've observed, would you say that the recommendation of that commission are taken seriously and implemented? And in other words, I guess what I'm trying to figure out is, as things stand, can we prevent another state capture?
Corruption has changed qualitatively and quantitatively. It's differently organized. State capture was on the surface, as it were. Everybody knew about Saxonwold. And the Gupta family didn't hide behind syndicates and other forms of secretive operation. It's changed now. Corruption is still there. It's still endemic. And so the whole problem of law enforcement and corruption is a systemic problem that is being addressed, and in my view should be addressed more urgently. When the report was issued, the President appointed the National Advisory Council, Anti-Corruption Advisory Council. It reported after 2 years to the President last year. That report still hasn't been made public. So the architectural change that was promised by the President 4 or 5 years ago still hasn't happened. And that's a serious issue. It really is serious. It's affecting people's lives. It's affecting people's livelihoods. It's affecting our economy. It's a serious issue.
Yeah. I want to ask about just your work when you were with the NPA as a consultant. Has your contract been renewed now? The last I checked with the NPA head, she had asked the Justice Minister around the renewal of the contract. Is that resolved now?
Yes, it's what termed a Section 38 appointment. In terms of legislation, the NPA cannot appoint outside consultants in terms of that section without the consent of the minister. It is not independent in that sense. And what I do know is that when my contract expired in November last year, application was made for its renewal.
Yeah.
And I haven't heard an answer. You can draw your own conclusions from that.
Do you think it's them saying no to you coming back?
Well, November, December, January, February, March, April, May, 7 months.
Yeah.
Long time to sign a
to make a
document.
consideration.
Yes.
Okay, one of the concerns that some people had, especially other political parties, was, isn't there conflict of interest here when Advocate Paul Pretorius, who was at the State Capture Commission, is now with the NPA? And I think the question a lot of them were asking is, what happens if someone says they want to take on review perhaps what the State Capture Inquiry's report said about them? What would you do in that
Firstly,
space?
I was a consultant. So I was advising at a systemic operational level, right? I can't go into detail because of my contract and I must obey that contract. Secondly, I did not involve myself in appearing in any prosecution. However, there would be no conflict because at the commencement of the commission, the regulations were changed to allow investigators and members of the legal team to move to law enforcement agencies and to take their knowledge with them. So that's expressly dealt with in regulations. The idea of a conflict of interest would mean that I have an interest specifically directed. I don't have any such interest. You know, I do a job as an advocate, and that's my job. I hold no interest in a successful or unsuccessful prosecution in any event, even were I to prosecute. So the whole idea of a conflict of interest is it's not a real problem.
Just as we wrap up, from what you've seen at the NPA, is there hope that we will see successful prosecutions? Because I think that's what a lot of South Africans are more concerned about. They want to see people in orange overalls because there's so much that was revealed by the State Capture Inquiry and they just want to see people held accountable.
These things take time. These are incredibly complicated matters. Let me just give you a brief example which may illustrate it to your viewership. In any prosecution that involves a common purpose or a conspiracy, you have to have evidence, detailed evidence of how that conspiracy was formed. You then have to have evidence as to how it was executed, not by the same people, but by people acting on instructions. And then you have to have evidence, complex evidence, from forensic auditors of where the money went. And then you put together all these in one picture. That's hugely complex. Not to say that there are not other problems with defences and delays and the like, which we all know about. So these are incredibly complicated prosecutions requiring a great deal of investigation with limited capacity, limited technology, and quite frankly, limited experience and skills. That's why outside advocates are being pulled in.
Advocate Paul Pretorius, thank you so much for making time for us. And thanks to you for watching the Thursday edition of Face the Nation. That's the Tuesday edition. We'll be back with you on Thursday at 8 p.m. Have a good evening. Cheers.